Angela's workers' comp claim was denied. She hurt her back at a UPS facility in Schaumburg in April, lifting a package that wasn't labeled with the actual weight. Filed the claim. Last week, a letter arrived. Claim denied. Not work-related, it said. She's in pain, she can't work, and her income stopped. In Illinois, a workers' comp denial isn't a verdict. It's the insurance company's opening position. Angela has options she doesn't know about yet. One involves a legal process the carrier counts on injured workers never discovering. Other involves a deadline that, if missed, makes all of it irrelevant. Let me say this as clearly as I can. A denial from workers' comp insurance carrier does not mean you lost. It means the insurance company made a decision. That decision is not final. Under the Illinois Workers' Compensation Act, you have the right to challenge a denial. The Illinois Workers' Compensation Commission, the IWCC, exists specifically to resolve disputes between injured workers and employers or their carriers. Workers win those disputes regularly, but you have to understand what you're actually fighting before you know how to fight it. The most common denial reason in Illinois workers' comp is the carrier arguing that the injury isn't work-related. That's exactly what happened to Angela. They say your injury is from a pre-existing condition, or it happened somewhere other than work, or that the mechanism you describe doesn't support the severity you're claiming. This type of denial is very common. It's also very commonly wrong. The second common denial is late notice. Under Illinois law, you're required to notify your employer of a work injury within 45 days of when it occurred. Miss that window and the claim can be denied based on timeliness grounds. There are exceptions an experienced attorney can evaluate, but the 45-day rule is real and it matters. The third type involves a dispute about the diagnosis itself. The carrier may not be arguing that nothing happened at work. They may be arguing that the condition your doctor is treating isn't actually connected to the work incident. A herniated disc that shows up on imaging 2 months after a fall at work may be disputed as a pre-existing degenerative condition that was there before the fall. The fourth type involves worker classification. Delivery drivers, gig workers, and independent contractors increasingly face denials based on the argument that no employer-employee relationship exists at all. That's a separate legal fight and one that can be won, given how Illinois courts and the IWCC have been analyzing the employment relationship in recent years. Each of these denial types has a specific response strategy. None of them automatically end your case. The Illinois Workers' Compensation Commission is the administrative body that hears workers' comp disputes in Illinois. When a claim is denied and you contest it, the process starts with filing an application for adjustment of claim with the IWCC. That's a formal legal filing that protects your rights and initiates the dispute resolution process. Once filed, the case is assigned to an arbitrator who will hear evidence from both sides. The IWCC has offices in Chicago and across the state, including Rockford, Peoria, Springfield, and Collinsville. Hearings are generally assigned to the hearing site closest to where the accident happened. Arbitration involves presenting medical evidence, records, your testimony, and potentially expert witnesses. The arbitrator evaluates everything and issues a written decision. After that decision, either side can seek review by a panel of IWCC commissioners. After commissioner review, appeals can proceed to the Illinois Circuit Court system and on to the appellate courts. This process takes time. A contested claim at the IWCC is not resolved in weeks. It could take a year or more to reach an arbitration decision, depending on complexity and scheduling. But it's a real process with real enforcement. And workers win these disputes every day. One of the most common scenarios in denied claims involve an IME report. The insurance company schedules an IME, the doctor says the injury isn't work-related or that maximum medical improvement hasn't been reached, and the carrier uses that report to deny or cut off benefits. IME reports can be challenged. They're challenged regularly. The arbitrators at the IWCC have significant experience evaluating the difference between a treating physician who followed a patient through their entire recovery and an IME doctor who spent 20 minutes with them on a single occasion. They know what they're looking at. A treating physician with thorough, consistent documentation carries real weight in that room. A strong treating physician relationship, solid medical documentation throughout the recovery period, an attorney who knows how to present this evidence at arbitration, that's the combination that turns a denied claim into a successful outcome. Here's what not to do when you receive a denial. Don't sign anything the insurance company sends you after the denial. Denial letters sometimes arrive with settlement language attached, or the carrier follows up shortly with an offer. Do not execute any release until you understand exactly what rights you're giving up and whether the amount makes sense for your case. Don't give up and walk away. I understand the temptation. You're hurt, the check stopped. An official looking letter on professional letterhead told you no. It feels like the door is closed. It's not closed. A denial is the insurance company's first move, not a court ruling, not a judgment. Their first move. Don't wait too long to contest it. The statute of limitations in Illinois workers' comp is 3 years from the date of injury or 2 years from the last date of payment of compensation, whichever's later. That deadline is absolute. Miss it and the claim is gone. One important clarification. Under Illinois law, the furnishing of medical services alone is not considered payment of compensation for purposes of this deadline. If you've been receiving medical treatment but no waves loss payments, the 2-year clock runs from the last actual payment of compensation, not from your most recent medical appointment. Have an attorney confirm exactly where your clock stands. Even before the deadline becomes critical, waiting hurts you practically. Evidence gets harder to gather. Witnesses move on. Medical records become more complicated to present effectively. If you've already received a denial, whether it arrived last week or has been sitting on your counter for a month, drop the denial reason in the comments. Tell me what they said. I'll tell you which response strategy applies. The most common denial types have clear paths to contest, and your situation is probably one I've seen before. Get an attorney, do it now. If you didn't have an attorney before the denial arrived, the denial is your signal. Contesting a workers' comp denial is a legal process before an administrative tribunal with specific procedural rules. Insurance carriers send experienced attorneys and adjusters to these proceedings every single day. Workers who walk in without representation are at a structural disadvantage against people who do this for a living. Workers' comp attorneys in Illinois work on contingency. Nothing up front. No hourly fees. You pay nothing unless you recover. There's no financial barrier to getting representation. None. The denial letter is not the final word. It's the beginning of the next phase. Call someone who knows what that phase actually looks like and how to win it. If an IME played a role in your denial, watch my video on what an IME is and why the insurance company schedules one. It covers exactly what you're up against. Subscribe so you don't miss what we release every week. And if you got a denial letter, call Connolly Injury Law. Free consultation. The denial is not the verdict. What reason did they give you? Drop it in the comments. I read every single one.